Hi, my name is Mark D. Copoulos, and I'm a Philadelphia criminal civil defense and real estate lawyer. And today I'd like to talk a little bit about depositions, what depositions are, and why depositions are critical to your case, and if you're a defendant, why a deposition may be your best friend. When most people hear deposition, the word deposition, they get scared. It seems like a confusing topic. It's something that you hear about in movies or on TV, but most people really don't know what it is. And all a deposition is it's an examination of a potential witness or someone who may have relevant information to a case under oath. It's an opportunity for one side, either the plaintiff or the defendant, to get more information about the case. And one of the central ideas behind a deposition is that there shouldn't be any surprises when a case gets to trial. Unlike in the movies, there shouldn't be an aha moment at trial where evidence comes out that one of the sides didn't even know about before the case ever actually got into court. Both sides are supposed to have all the cards kind of down on the table before they get into court. And that's what a deposition is. It's an information gathering process. Either the defendant or the plaintiff's attorney will notice the other side or will notice a relevant witness for a case and take their deposition. Now, before COVID, most depositions were done in person at an attorney's office or at a designated third-party location. Post-COVID, at least in Philadelphia, the majority of depositions for cases, non-major cases, less than 50,000, are being done on Zoom. And so what will happen is the attorney will send out a Zoom link. Both the attorneys and the party will appear for the deposition, and their questions will be asked. And the individual who's being deposed will be under oath and will have an obligation to speak the truth. At the same time, if it's one of the parties that's being deposed, either the plaintiff or the defendant's counsel can raise objections and can be there to kind of make sure that no inappropriate questions are being asked and that the other side is asking questions that are relevant to the litigation at hand. So why is a deposition important to your case? In my experience, countless times after a deposition, a case that may be on the fence will settle after a deposition. And the reason for that is because at the deposition, both sides, the plaintiff's attorney and the defense attorney, are gauging the credibility of their witnesses. If the plaintiff's testifying, the defense attorneys have a chance to look at this witness. What is this witness going to look like when she takes the stand? Is her story believable? Does the witness have credibility? Does the witness seem to have integrity? Does the story make sense? If you're the defense attorney, you have a chance to cross-examine the plaintiff about their story, inconsistencies that may exist in their story. And if those inconsistencies are exposed at a deposition, the plaintiff's attorney may realize that they need to settle the case or that they don't have a case. And it's important to remember that plaintiff's attorneys in a personal injury case are almost always working on a contingency fee, which means they are not getting paid up front. The only way that the personal injury attorney is usually getting paid is if they recover a verdict or if they settle the case for a monetary amount before or after the trial. So if the plaintiff's attorney is sitting in the deposition and they hear their witness testifying and they realize this is not a strong case, this witness doesn't have credibility, this story doesn't make sense, this plaintiff has been sued 3 times before or has filed actions 3 times before for personal injury cases, for example, or has criminal charges, or their story just doesn't make sense, you may have an opportunity to score major points at the deposition, to get information about what this case is going to be about, and does this witness have any credibility at all. And it's also worth noting that if you push the other side to a deposition, a lot of times either the plaintiff or the defendant may not appear, may be afraid of the deposition, may not be sufficiently invested in a weak case to even appear for deposition, and the opposing party can then file a motion for preclusion if it gets bad enough, asking the court to enter an order that the person who failed to appear cannot testify in court, or even the plaintiff may not be able to present evidence if they're not in compliance with a discovery order, if they failed to adhere to the rules of discovery. So again, the idea behind a deposition is that all of the cards should be out on the table. Both sides should know what this case is about. There shouldn't be any surprises. And when you do depositions, you get a better understanding of the case. You get a better understanding of the credibility of the witnesses and the information that's going to be presented at trial. A lot of defense attorneys and defendants who are perhaps doing the case on a budget don't want to spend the money on a court reporter, don't want to spend the money on interpreters if the person being deposed speaks another language, say, oh, we'll just skip the deposition and we'll go forward to trial. That could be a fatal mistake, because if you're thorough, if you take the depositions in advance, there may not even be a trial. You may be able to settle the case for pennies on the dollar, or the plaintiff may realize they don't have a case and they don't want to keep sinking money into a case that is not going anywhere if their client doesn't have credibility. So a deposition, the discovery process generally, is a great opportunity to win a case. It's a great opportunity to get more information, to thoroughly review the case, and it may give you leverage in settlement negotiations. My name is Mark D. Copoulos. I'm a Philadelphia criminal, civil defense, and real estate lawyer. If you've been sued, if you're not insured, a premises liability case, a slip and fall, a car accident, and you're looking for an aggressive defense attorney to protect your rights, contact our office at 267-535-9776 for a free, no obligation consultation. And as always, thank you for watching my blog.